Good morning, everyone. I'm JP Fritz. I'm the Vice President of Financial Lawyers Conference this year, and I'm pleased to welcome you to day 2 of our Nuts and Bolts program. We have 2 presentations on for this morning. At 9 o'clock, we're now starting with John Tedford and Monse Morales, who are going to give us presentations about bankruptcy avoidance actions. And then at 10 o'clock, we're going to have Chapter 11 plan confirmation issues with David Golubchik and Jonathan Weiss. So with that, I'd like to turn it over with great thanks to John Tedford and Monse Morales. Thank you.
Thanks, JP. Leslie, can you turn on screen sharing for me?
Yes, give me one quick second. Sorry about that. It should have been on. I apologize.
Good morning, everyone. Thank you for joining on a Friday morning. So we're talking about avoidance actions, and just to give a little background. So bankruptcy, as you probably heard or know, is basically a court of equity. Parties come in and expect that creditors will be treated fairly under the code's provision for distribution, and that the debtor will be required to pay the extent that they can pay. If they were to liquidate, you'll get some of that more information on plan confirmation in the next session. But one of the things that aids the estate is the avoidance powers, which lets a debtor or a trustee, and sometimes other parties, we'll talk about that in a bit, recover monies or property that the debtor transferred prior to the bankruptcy, and in some cases after, but mostly prior to the bankruptcy, if they meet certain criteria, predominantly preferential transfers, which we'll get into, meaning they pay one creditor over others, and fraudulent transfers, which are transfers made without receiving equal benefit. And that's a very short summary of fraudulent transfers. We'll get into that as well. So the idea is to bring money or property back to the debtor's estate that was transferred close to the petition date and let it be equitably distributed to the creditors in accordance with the code. So there are very important provisions that allow an estate to basically bolster its coffers for creditors. So let's get started.
All right, so Monse, I got to ask the obligatory question. Is the share screen, you seen the full screen with the PowerPoint?
We're just seeing the slides.
Very good, all right. So the first thing we're going to talk about today are preferences or avoidance of preferential transfers. And what Section 547 of the Bankruptcy Code allows is for a debtor or a bankruptcy trustee to avoid and recover certain transfers or payments of property of the debtor that are made within a relatively short period of time prior to the bankruptcy filing. And as we'll discuss in a moment, the definition of transfer is very broad in this context. It includes voluntary transfers as well as involuntary transfers. So it's easy to envision a preference action applying if I have a pen and I actually transfer ownership of this pen to Monse. And the question is whether or not, for example, she gave full value or something like that for that transfer. But it also involves involuntary transfers. So if Monse were a secured creditor and she came and she took my pen in order to try to satisfy her her claim against me, that would also come into play in connection with whether or not that transfer is avoidable. The other type of transfer, and I've just kind of alluded to this, is it not only applies when I transfer ownership of a widget to Monse, it also applies when I transfer an interest, a security interest to Monse. So one of the things as we talk about this, both in the context of preferential transfers and also fraudulent transfers, is that the definition of transfer is broad, and a lot of things that you might not think are transfers actually are for these purposes. Preferential transfers are, or the ability to avoid a preferential transfer is an equitable remedy. The idea here is if a payment was made to a creditor shortly before the petition date, we want to be able to get that money back into the estate and pay that money out to creditors on a pro rata basis. And Congress has made the policy decision that that is one of the primary policies of the bankruptcy code. And as a result, trustees or debtors should be able to claw back money that they paid to creditors. One of the things about preferential transfers that's hard for people to understand, especially the defendants after they've been sued, is that they haven't necessarily done anything wrong. And yet, I'm sure Monsi's had the same thing. You file a preferential transfer claim, that you get a call from the defendant and they say, but wait a minute, the debtor owed me this money. And your response is, yeah, the debtor did owe you this money and the debtor paid you what you were owed, but you still now have to give the money back. And so while from our perspective, we view this as an equitable remedy, from the defendant's perspective, this is extremely inequitable because it feels unfair to the defendants that they have to give anything back. And in fact, almost by definition, the defendant has done nothing wrong. They've merely received payment for a debt that they were owed. This isn't used by debtors who are reorganizing a lot, and that's because the debtors don't want to tick off the trade creditors that they've paid prior to the petition date. And so Chapter 11 debtors in possession usually don't file preference actions. So we see these more in the context of Chapter 7 cases or Chapter 11 cases where a trustee has been appointed or where it's a liquidating case. And in those sorts of cases, this is a really valuable source of recovery. Sometimes it's the only money that a Chapter 7 trustee can get back in order to distribute to all creditors, is money that the debtor happened to have paid out. And the last thing I want to note about this slide is we call it a preference. And in my mind, that always makes me think that the transferor, the debtor, preferred the recipient. There is no requirement that the transferor actually have intended to benefit the recipient. In fact, sometimes these preferential transfer cases come into play where the debtor is actually feeling a pinch from the recipient. So it's don't look at, even though it's called preference, don't think of it in terms of the debtor actually affirmatively in his or her mind expressing a preference by paying the creditor. It just happens to be, that's what these types of actions are called. So who can bring a preference action? Chapter 7 trustee, a Chapter 11 trustee, a debtor in possession in a Chapter 11 case. The way that the code is written, when you read section 547, it refers to the trustee avoiding the transfer. But then in Chapter 11, it says the debtor, when the debtor is acting as a debtor in possession, has all of the rights of the powers of a trustee. And as a result, a debtor in possession is able to bring these sorts of claims. Now, Monsi came up with a really interesting question when we were putting together these slides as to whether or not a sub-Chapter 5 trustee would have standing or at least authority to file a preference action, because in a sub-Chapter 5 case, at least at first, you have both a debtor in possession and a trustee. Monsi, what's a reason you could think of that a trustee shouldn't have standing or authority to file a preference action?
Well, and I'm not sure if there were any discussion about sub-Chapter 5 cases. I would hope so. In some of the other presentations, it could get into a little bit more of the meat of that new, those new provisions. But in sub-Chapter 5, the trustee who is appointed automatically has a very defined role under the new statutory provisions. And the primary goal is to help the parties, the debtors and the creditors, negotiate a consensual plan. There are not a lot of other affirmative, take action type of duties for a sub-Chapter 5 trustee if he or she is not in possession of the debtor. The debtor is still a debtor in possession and runs its business, operates the case, administers the estate, and is really the one handling, just like a normal Chapter 11 case would do. So that the sub-Chapter 5 trustee is there, is monitoring, is helping, is communicating, but is not doing the, taking the administration of the estate from the debtor as a typical trustee would. So in many cases, I would argue that the provisions of Chapter 11 that allow the debtor in possession to exercise the role of a trustee in the bankruptcy code, such as avoidance powers, it still stays with the debtor in possession. There's no affirmative provision in the code that would give that power to a subchapter 5 trustee. And in addition, the powers that would come under for a Chapter 7 trustee, many of those are expressly excluded from a subchapter 5 trustee's duties.
We'll ask JP Fritz later during the networking hour whether or not he thinks sub 5 trustees have authority to bring preference actions. I did call a couple other sub 5 trustees, and one of them said, well, I don't know, haven't done it, can't really envision myself doing it, but what you should do is you should check to see if Chapter 13 trustees have that authority. So I did some quick Google research and found out that Chapter 13 trustees do have authority to bring preference actions, even though I've never seen one. So maybe they do. What we do know is when a court authorizes a creditors committee or maybe even another creditor to file a preference action, then the committee or that other creditor can do so, but needs to get authority to do so because they really are filing on behalf of the estate, not on their individual behalf. So
And I think
Monty,
one of the more, oh, sorry, one of the more,
go ahead and then go on to the elements.
okay, yeah, one of the more common times I think you would see a committee or perhaps another creditor, a larger creditor or creditor body taking over the avoidance action is through a Chapter 11 plan. They can frequently be assigned to a post reorganization committee or some other creditor as part of that, because, and that's usually a negotiating point where, maybe the creditors or the creditor committee are saying, well, there's all these potential preferences that were done, maybe to insiders or maybe to certain trade creditors. And the debtor, like John said, the debtor doesn't want to touch that for various reasons, mostly because it wants to continue its good relationships through its business.
Especially if it's an insider, right?
Right.
The debtor's not going to sue
they
its
don't
own
want-
insiders. So
That's right. And there could be conflicts potentially. So often the creditors committee or so other parties will say, well, give those to us and we'll take over that. And if necessary, bring the litigation. So that frequently happens in a plan scenario. So going to the elements of a preference, the traditional elements, there are several. First of all, it has to be a transfer, and John talked about the broad scope of transfer. Secondly, it has to be to or for the benefit of a creditor. So it has to be somebody who is owed a claim or has a claim against the debtor. And again, that's a very broad definition if you look in the bankruptcy code definitions. It has to be for or on account of an antecedent debt owed by the debtor. So again, when John talked about a creditor who said, yeah, but the debtor owed me that money, that can't be anything wrong with the payment I received. Well, that is actually an element of a preference. It's not a preference if the debtor just gave you money and didn't owe you anything in prior to that. In fact, that would be probably a fraudulent transfer. But preference, it requires that it satisfies an antecedent debt. And that's, again, because of the equitable provisions of bankruptcy in wanting all creditors to be paid equally if they have similar types of claim or if they're similarly situated. It has to be made within 90 days prior to the petition date. And this is very important because debtors will frequently time their filings to make sure they're within the 90 days. If they have preferences or payments that have been made or involuntary transfers that have been made to creditors, like if a creditor filed an abstract of judgment and got a lien against their home or something, or repossessed some property, or, as John mentioned, maybe pressured the debtor into making a payment that it wasn't able to do or didn't want to do, and so forth. So the debtor can file bankruptcy as long as it's within 90 days after that transfer, and then it will be encompassed into potential avoidance transfer. So, and another thing to keep in mind is when you are talking about transfers to or for the benefit of an insider is defined fairly broadly in the bankruptcy code. It can be affiliates, it can be, subsidiaries, it can be officers, directors, family members. Then the look back period is 1 year. So it's a bit longer because I guess that people are concerned that insider transfers may occur a little bit more frequently, or maybe considered more preferences that they want to avoid in the year leading up to bankruptcy. And then finally, the last element, I'm sorry, one of the last elements is that the debtor was insolvent when the transfer was made. And then that the creditor was allowed to receive more than it would have under a liquidation in Chapter 7. So that test is probably one of the most litigated, because you have to get to liquidation value of the debtor, and you have to look at whether that creditor, what potential class that creditor is in. For example, if the creditor is a secured creditor and the debtor prior to the bankruptcy gave them a huge payment to pay down, maybe they were really pressuring the debtor, or threatening to foreclose, so the debtor made a huge payment. Well, if that creditor was fully secured with enough collateral to satisfy its debt in full, it would not satisfy this last element, because in a Chapter 7, and if the debtor liquidated, the creditor would receive up, the full value of its claim up to the value of the collateral. So if the collateral is, the value of the collateral exceeds the claim, that creditor would have been paid in full in a liquidation from the sale or other liquidation of that collateral. And therefore you cannot argue or prove that it received more than it would in a Chapter 7. So secured creditors, if they can prove as a defense that they were fully secured or oversecured, are generally shielded from preference liability. But that could definitely be a litigation point if the debtor can show that they are undersecured, or that the collateral value is lower than the amount of the claim. That is frequently a point where there might be some litigation in place there. And of course, the creditor is only secured because of a quote unquote preferential transfer. For example, they filed their lien, or they filed something to perfect their lien within 90 days of the petition date. They may be secured as of the petition date, but that transfer in and of itself is avoidable. And if it were avoided, they would not have received the benefit of a lien and security under a Chapter 7. So they are, that would be a transfer that could be avoided. And
Right. So
go ahead.
So you heard Monse refer to the liquidation element as the last element. And that's because historically, what the elements that Monse has gone over are the elements that apply to at least the prima facie case of a preference action. And a few years ago, Congress added a couple of things to the bankruptcy code as well as to the judicial code in an effort to curb perceived abuse by trustees in filing preference actions. The idea here is that trustees start getting to the 2-year time period maybe, and they don't really do a whole lot of research into who it is that they're suing and whether or not the people they're about to sue have decent defenses, or maybe, they just don't even bother waiting. Maybe they're not even under the gun near the 2-year statute of limitations period that we'll be talking about in a little bit. Maybe they just decide, you know what, we're just going to sue everybody who ever got any money from this debtor within 90 days pre-petition. We're in Delaware. These guys are all in Minnesota. They're not going to want to hire a Delaware counsel to come defend it, which means they're low-hanging fruit for some easy settlements. And Congress saw this as an abuse and decided to enact a couple of provisions, including one in Section 547B. And the reason why I think it's important that this was added to 547B is because Section 547 says that the trustee or the debtor has the burden to prove all of the elements under 547B, while the creditor is the one that has the burden to prove the defenses under 547C that we'll talk about in a moment. Because Congress put what I'm about to talk to into B, I think it actually creates a new element, or maybe even 2 new elements. And the plaintiff is supposed to, the action is supposed to be based upon reasonable due diligence in the circumstances of the case. I have no idea what that means and what the edges of that requirement are. And then it has the word and would signify that these are two separate, distinct things, taking into account a party's known or reasonably knowable affirmative defenses under subsection C. Now, what this tells me, and what the policy of this provision is that the plaintiff is supposed to sit down and think about what defenses the defendant's going to raise and not sue a defendant who is probably going to have a defense. Now, technically, it doesn't say you can't sue them. It just says that you're supposed to take them into consideration. I can take it into consideration and still sue you, figuring you're not going to defend because I'm in Delaware and you're in Minnesota and you're going to pay me 50% of what I want. But I think what this means is you're not supposed to sue people who you think have defenses. It means you have an affirmative duty to actually try to investigate those defenses. And you probably in the complaint need to plead that you've done that. And once we go down that path, the question is ultimately, say at trial or on an MSJ or a motion for default judgment, you probably ought to prove or be required to prove that you actually did take steps in order to figure out what defenses the defendant had. How that plays out in discovery, I don't know. I've never actually seen this play out in the course of a preference action ever since these new requirements came into place a couple of years ago. If I were a defendant, I would see that as a little bit of a gold mine in discovery. I'd want to know what steps did the trustee or the debtor take in order to figure out what my defenses are? What documents did the plaintiff rely upon? And in discovery, I'd say, why don't you give me those documents? Because it could be that the plaintiff's financial advisor or accountant has done a really great job of identifying all of your defenses and can do some of your work for you. So if I were a defendant, that would be something that I'd be really interested in seeing from a plaintiff. So with respect to defenses, there's a list of them, and we're going to go over the major ones, and then we'll go quickly over some of the minor ones. One of the major ones is a contemporaneous exchange for new value. It's 547C1. The defendant must show, and again, this is the defendant's burden to prove this, that the parties intended the transfer to be a contemporaneous exchange. It actually was contemporaneous, and it was for new value. And the idea here is we want to encourage creditors to continue to do business with debtors who are kind of like on the verge of filing for bankruptcy. And we don't want them to fear that they're going to be sued for preferences by that trustee in Delaware, because who's going to sue everybody anyway. And so an example of where this can come into play is, let's say a debtor pays a creditor $50,000 in exchange for the release of a lien. Well, if the value of the property that lien attaches to was $50,000, the creditor is deemed to have given contemporaneous, has provided a contemporaneous exchange of new value, i.e. the release of the lien. And this section would shield that cash payment from avoidance. Now, Monsi mentioned a little bit ago, and this kind of comes into play with the 547B5 element, that what if the property only has a value of $30,000, and therefore the lien that you are giving up really only has a value of $30,000, and you're giving up this $30,000 lien in exchange for a $50,000 payment. It means that only $30,000 is protected by this exception, and the other $20,000 is still subject to avoidance unless it comes under one of the exceptions. So another one of the exceptions that comes into play is, and this is another big one, is the ordinary course of business exception, and Monsi's going to talk about that.
Okay, so this is probably one of the most raised defenses by potential defendants or actual defendants in a preference action. If the defendant can show that the debt was incurred by the debtor in the ordinary course of the debtor's business, and well, let me stop there. So that means, let's say this is primarily for trade creditors. So if the debtor is, a medical clinic, for example, and it orders braces and syringes and so forth on a regular basis, then that would be debt that it incurs on a regular basis. If the debtor decided to send all its employees to Hawaii for Christmas, that is not a debt that's incurred in the ordinary course of business. That is not what they're in the business to do. So those types of payments might be, would not fall under ordinary course. So that's the first thing. And usually that's a pretty easy thing to show. Again, you know what the debtor's business is, and you figure out if the debt is incurred in the ordinary course. The second criteria then is that the debt that was incurred and that was paid in the ordinary course of business between the parties or made according to ordinary payment terms in the industry. Now, this is the defendant can show either one of these. Let's say they have payment terms of 15 days. Maybe this was something that was arranged so that the creditor was really concerned from the get-go. And so for the past 3 years, they have said, well, we'll give you these items on credit, but you have to pay in a 15-day period. And so the debtor makes payments every 15 days to this creditor upon being invoiced. Well, that would be the ordinary course of business terms between the parties. So if the creditor can show that's what they've done for a period of time, then that would satisfy this element, and they would likely have a valid defense. Alternatively, they can show that the payment was made in ordinary payment terms in the industry, which that would likely require expert testimony that would say, well, in the shipping industry or in the restaurant industry, you pay for whatever goods or services every 30 days or every 45 days. And that's exactly what happened here in this case, the defendant would argue. And again, that's something that the defendant would have to prove, likely with expert testimony or other evidence as to what happens in the industry. And the debtor or trustee, whoever's bringing the case, can try and argue against that and say that's not the case. But the interesting thing is that the or between those two provisions is fairly new. It was put into place in 2005 with the Bankruptcy Consumer Protection Act, the BAP-CIPA, in 2005. Prior to that, it was required that the defendant show both of those. So you would have to, it was an and. So the defendant would have to show that the payment was made in the ordinary course between the parties, and that those terms essentially were ordinary payment terms in the industry that the debtor is in. And that's a little bit difficult, because if you make any kind of special arrangements with the debtor as a trade creditor or any kind of creditor that didn't comport with what the ordinary business terms are in the industry that you're in, you might have lost this defense in the ordinary course. And so in order to provide the defendants with a more reasonable, I would say, defense opportunity is to say, well, it's an or. Is this how you guys have regularly done business that you can demonstrate? Or is this how people in the industry do it? And again, prior to the BAP-CIPA, the second provision, which was conjunctive, it was an and, it also said the payment was made according to ordinary business terms, and that ended. Now, courts interpreted that to mean ordinary business terms in the industry, but it wasn't specifically spelled out in there. So you could just say that was ordinary business terms, that what we had in addition to the ordinary course of our business. So again, I think this is one of the more common defenses that comes up. It's also one of the easiest probably for a trustee or debtor in possession, whoever is the plaintiff, to review or verify, as John was saying, that these new quote unquote elements where you have to take into account the potential defenses. You can see, or you should be able to see, every transfer made to a defendant in the 90 days prior, and see if it's an ordinary course, because the debtor has to disclose those in their initial bankruptcy papers, their statements of financial affairs. So if you're seeing every 30 days, $6,000 going to trade creditor one, that's probably sufficient, where the trustee should have taken into account that that might be the ordinary payment terms between the debtor and that defendant.
All right, so another one, which is not one of the major ones, but is also important for trade debt or for loans for businesses, is the purchase money security interest exception. The idea here is debtor wants to buy a widget and needs the financing to do so. And so debtor borrows the money and then, say 30 days later, buys the widget, and at that time, in connection with its loan agreement, it grants a security interest, or a security interest attaches in favor of the lender who gave them the money in order to buy the widget. As long as that security interest is perfected within 30 days, then the granting of that security interest is not considered to be preferential, or rather a defense to the preference action exists, and that transfer on account of the antecedent debt cannot be avoided. Let's go on to one of the next major ones, which is the subsequent extension of new value. Monse, this one's yours as well.
Yeah, so this one is very similar to the new value exception, or the contemporaneous exchange for new value that John mentioned earlier. But in this case, it can be a subsequent extension of new value. So this typically occurs when there's subsequent loans or advances on a line of credit, or new loans, where a defendant can show that they gave new value to the debtor after the payment. So again, this encourages trade creditors and also financial institutions to continue to lend or do business with the debtor, and reduces the exposure to them. So what happens is, if, let's say, you have a debtor has an unsecured line of credit, they pay it down $100,000, and then subsequently the lender allows them to borrow again or advance another $75,000 right before the petition date. Well, the $100,000 would typically be avoidable, except they have a subsequent extension of new value defense, which is a dollar for dollar reduction in their potential liability. So arguably, they would only be potentially liable for the $25,000 difference between the payment that they made that could be considered a preference and the new value that they extended subsequently. And again, this is probably another one of those types of defenses where a trustee or debtor in possession could easily take into account, because it would be disclosed or easily identifiable in the schedules or statement of financial affairs of the debtor.
So here, let's real quick, three of the minor ones, or at least the ones that are litigated less frequently. There's an exception for, or a defense for, statutory liens. And really this is because there's a different statute in the bankruptcy code, section 545, which governs the avoidance of statutory liens. And therefore preference actions can't be used in order to avoid those. You have payments made on account of domestic support obligations, such as alimony and that sort of thing. And then you have these minimum aggregate value requirements, so that in 547, you don't sue people for, I don't know who would ever sue somebody for $500 in the aggregate, but these limits to me seem way too low if the real goal is to keep trustees from suing people who, didn't really receive enough money to warrant suit. But these are the exceptions. The $600 exception applies when you have an individual debtor and the debtor's debts are primarily consumer debts. The $6,825 exception applies to debtors whose debts are not primarily consumer debts.
And those limits, at least the second one, are subject to increase, I believe, every 4 years or 3 years.
But the baseline is so small, the increase doesn't really
The increments are
come into
tiny.
play. All right, so Monty had talked about the insolvency, how one of the elements of a five prima facie case is that the debtor be insolvent. And there's a presumption that really helps debtors and trustees here. Monty, why don't you go over that?
Okay, insolvent, so insolvency is, or insolvent is defined in the bankruptcy code, as I put there. Debts exceed the assets at fair value, and that excludes the property that's been transferred fraudulently and exempt property. So the debtor may have, and this, now that they've changed some of the homestead exemptions, you know, they could have really large exemption in their home. Any other exempt property or the property that was transferred is not counted. So that, you know, will diminish the value of the estates when making this analysis. And you get the presumption of insolvency for preferences for the transfers done within the 90 days or for the 90-day period. There's a presumption that the debtor was insolvent 90 days prior to the bankruptcy. Now the defendant can rebut that and say, no, they were clearly solvent and therefore this is not a preference. But otherwise, if it's not rebutted, that factor is just considered demonstrated for purposes of trial. Okay, so look back periods. As we talked about, the most transferees have a 90-day period where the debtor or trustee can look back to the transfers. Otherwise, for insiders, which is defined very broadly, and we gave some examples here, it's for 1 year, a 1 year period. And the insolvency presumption that we just spoke about is not in play for any period after 90 days prior to the bankruptcy. So it's not presumed in a transfer to an insider beyond the 90 days to the 1 year period.
All right, I mentioned a moment ago the defenses that exist for transfers that are in the aggregate really small. There's, and I also mentioned earlier about how Congress put in some provisions that were designed to try to prevent or address perceived abuse by trustees in suing people for small preferences. One of the other, in addition to the potentially new elements of 547B, one of the things Congress did is they revised the venue statute, which is in the judicial code, not in the bankruptcy code. And we could geek out on this for half an hour later if you really want to. But the point here is there's a question about whether or not this venue provision actually applies to preference actions. Congress thinks it does. I don't think it does because of an error in the drafting. But what some people believe this means is that if you file a preference action against somebody for less than $25,000, you have to sue in the district where the defendant lives or resides, not in the home district of the bankruptcy case. Over $25,000, you can sue wherever the bankruptcy case is. Under $25,000, you might have to sue in the district where the defendant lives, and that puts that Delaware debtor in the position of having to go to Minnesota, which it's not going to do, Congress thinks, and that's why Congress set these limits. So those are preference actions. So now let's talk real briefly about fraudulent transfer actions, because we only have 20 minutes, Fonzie. And so why don't we start introducing it? Go ahead.
Okay, so fraudulent transfer is another avoidance power that a debtor or a trustee has under the code. There are two separate provisions under the bankruptcy code where you can do a fraudulent transfer. We'll briefly touch on both of those. And frequently when you plead in a complaint, the plaintiff will do it as an alternative, because as we mentioned, one of the factors in a preferential transfer, you have to show that the transfer was made on account of an antecedent debt. Well, if the defendant can somehow show that there was no valid debt or debt for a preference in existence, then you have an alternative pleading. Well, if there wasn't a debt, then the debtor didn't get any value for whatever payment was made, and therefore it's fraudulent. So sometimes it is pleaded in the alternative in an avoidance complaint.
All right, so there's different kinds of fraudulent transfer claims. One of them we call actual fraudulent transfer claims. And that's when you have a transfer made or an obligation incurred with actual intent by the transferor, not by the transferee, but by the transferor to hinder, delay, or defraud creditors. Well, the likelihood that you have a debtor who's going to go on the record and admit that they made a transfer in order to hinder, delay, or defraud creditors is pretty small. I actually have had a debtor, like an honest debtor, who admitted that he had been dishonest. So that came in handy later when we sued some people, but it's pretty rare. And so as a result, both under federal law and under state law, we have these things that we call badges of fraud. And these are basically facts that may exist, which evidence fraud, and then an accumulation of these facts, if they exist in your particular case, can justify a finding by the judge or a jury, if there is a jury, that there was in fact an actual intent to hinder, delay, or defraud creditors. If the transfer was to an insider, that raises a red flag. If the transfer had been concealed by the debtor, that raised a red flag. If it was substantially all the debtor's assets, so these are like basically red flags that, when there's enough of them, can justify a judgment in favor of the trustee or the debtor in possession. The other kind of fraudulent transfer is called constructive fraudulent transfer. And Monse, why don't you go ahead and talk about that?
So constructive fraud is where you don't know what the debtor was thinking. You can't prove, that they intended to do it, but the effect was the same. The debtor transferred some type of property or property interest and didn't get reasonably equivalent value, which is, again, that's a heavily litigated point. If it goes to trial, is what was the value that the debtor or the estate should have received, and was it received? And then it also must have occurred when the debtor was insolvent, or these other definitions which tend to be equated to insolvent, which is, including the transfer. So it became insolvent because of the transfer. That's one of the primary ones that it can be shown that are transferred its asset, its major asset prior to bankruptcy. So it's insolvent. So you want to focus on the value that the debtor gets, and it can be direct or indirect. So let's say you have a debtor who, and I see this a lot for some reason with affiliated debtors or subsidiaries, like one debtor will take out a loan and a subsidiary or parent will put a lien or, will guarantee or put a lien on their assets for that loan. Well, it can be argued potentially that that debtor that gave the lien or gave that transfer didn't get any value for it. The money all went to the affiliate. So potentially that could be argued that that was a benefit to the other debtor and not to this debtor, and therefore it can be avoided, or it's as an indirect benefit. There's no presumption of insolvency. So unlike the kind of factor that's already satisfied for many plaintiffs, in preferential transfer, you don't have the same presumption in a fraudulent transfer. And then there are some employment contracts where that doesn't apply. That's pretty limited.
All right, under section 548 of the Bankruptcy Code, there's a 2-year look back period. So you're able to avoid transfers that occurred within 2 years prior to the petition date. Going to some of the defenses, and of course that could be raised as a defense as well as part of the, maybe it should also be made as part of the affirmative prima facie case by the plaintiff, but it can be raised as a defense. Another defense is by a good faith purchaser. So to the extent that a purchaser gave value for the transfer and acted in good faith, then you're not able to go after the recipient of the transfer under section 548. I'm going to skip, well, I'll just quickly on this slide point out that if a transferee received in good faith and the transfer can still be avoided, it's unfair to punish the transferee if the value of the thing that was transferred has increased as a result of improvements made by the transferee, him or herself or itself. And in that case, what the code does is it gives the transferee a lien to the extent of the improvement, so that if the trustee gets that property back, liquidates it, the transferee basically gets part of the sale proceeds in order to reimburse him, her, or it for the improvement. How about the mere conduit defense? This can go for 45 minutes, but you have
I'll be
about 45 seconds, Monsi. Go ahead.
Right, I'll be quick. So this is not your bread and butter fraudulent transfer, at least, not really in the Central District of California, but because it is a very specified transaction that is covered under here. So in 546E, the bankruptcy code provides what people consider to be a safe harbor, or at least it did. And it relates to settlement payments or margin payments, so types of securities or settlements that are, distinct types of transaction. But if that's the transaction you're talking about, if the transfer was made by, to, or for the benefit of, and then it has a big list of types of entities, and one of which, the most important, I think, for this defense in where it was litigated, is financial institution. So we're talking about a bank, then they would be covered by the safe harbor. So many defendants would argue that they have this safe harbor because their transaction was made by, to, or for the benefit of a financial institution. Well, almost all transfers of money are made through a financial institution. And so this was being perceived as being an abuse when parties A and D were arguing, or at least party D, the ultimate recipient of the transfer, was arguing that, well, A transferred to B, which was a financial institution, who transferred it to C, who was our financial institution, and then we got it, and therefore those intermediary stops to financial institutions shielded this transfer into the safe harbor, and therefore you cannot recover that. Well, in 2018, the Supreme Court had their decision of Merit Management Group, and they found in a unanimous decision that where a transfer is avoidable, and if it involves intermediaries, that 546E only states that the only relevant transfer, I'm quoting now, the only relevant transfer for purposes of the safe harbor is the transfer the trustee seeks to avoid. Meaning you look to the last one, you look from A, the debtor, to D, the ultimate recipient, and is that one shielded by safe harbor? Are they a financial institution or other, commodity broker or one of the other types of entities that are covered in 546E? If not, then this defense is no longer available. So there's been some argument in a few cases that have tried to limit that a bit. I mentioned some of them down below. But in effect, that defense is largely gone.
All right, we're gonna skip over these two issues, but we'll note that there are issues relating to settlement payments that are made in connection with securities transactions. There's also interesting fraudulent transfer issues that come into play when you have LBOs. But let's skip forward here, Monsi, to this slide where we talk about the ability of a trustee or a debtor to use state law in order to avoid transfers, even though the debtor itself is not a creditor who would normally have standing under the state law.
Right. So in 544B of the code, the bankruptcy code gives the trustee, which, as John mentioned, is those powers are also given to a debtor in possession, state law avoidance rights of unsecured creditors. So if in California, for example, there existed a creditor that could, without the bankruptcy being in place, could avoid a transfer made by the debtor to another party, then the trustee or the debtor in possession gets the standing of that creditor to bring that action in bankruptcy court. And that helps because in the bankruptcy code, as we mentioned earlier, fraudulent transfer look back period is 2 years from the petition date or from the order for relief, which is typically the petition date. But in state law, it's often longer. For example, in California, a creditor can bring a fraudulent transfer action within 4 years. So in the bankruptcy code, the debtor or debtor possession gets the right to look back 4 years.
And possibly 7 under some circumstances, right? With discovery rules and that sort of thing.
Right. There are, to the extent that there are look back periods in state law that exist that you could argue would apply to the transfer at issue, then you can bring those into bankruptcy court and use that same statute of limitations. The only thing that's must be shown in addition to the traditional elements of a fraudulent transfer, which are the state law ones are almost exactly the same as the debtor. I mean, as the bankruptcy code, meaning you can show actual or constructive fraud. But you have to show that there existed a creditor that could have brought that, so that you can show you have standing because there was a creditor and you're just stepping into the shoes of that creditor under state law.
There's also been some interesting developments in connection with whether trustees and debtor in possessions can use the look back periods that the IRS has under federal law in order to even go further back than the 4 years. There are some cases, and I don't think there's a Ninth Circuit case on this, but there is a case by Judge Pappas, I think it is, out of Idaho, in which he talks about the ability of a trustee to use the IRS look back periods. There's a 6-year look back period under the Federal Debt Practices Act, I think, as the same initials as the Fair Debt, the FDCPA. So, it was confusing as to which one it is that we're talking about, but there's a federal act which applies to the IRS, which gives it a 6-year look back period. Also, the IRS has 10 years from the date of assessment to start collecting. And so some courts have held that that 10-year period provides a look back period for fraudulent transfer claims. I'm not sure that I'm sold on that, but some courts have adopted that rule. So now let's talk about post-petition transfers, just in case debtors, this only happens when there's debtors, right? Not trustees. Debtors make transfers that they're not supposed to. A trustee or a debtor in possession can avoid a transfer of property of the estate if it occurs after the case and if it's not authorized by the code or by a court order. I'm not sure I've ever seen a debtor in possession sue someone to recover a transfer that it made without court authority. So usually this is a trustee actually filing this sort of an action. Some examples where this definitely comes in is where the debtor was put into bankruptcy in an involuntary case, or actually this isn't an example, these are complications. When an involuntary petition is filed against a debtor, there's a period of time that we call the gap period, where before an order for relief is entered, and the debtor is authorized under the code to do business during that time period. And so those are probably, even those are post-petition transfers, they're probably still authorized by the code as long as the transfers occur in the ordinary course of business. And then another thing that I ran into recently is the question of what if a creditor actually has a lien on the property and then the property is transferred in satisfaction of that lien? It's technically a violation of the automatic stay, probably. It would also be a post-petition transfer, but there's kind of like a no harm, no foul sort of approach. And we sued a party who made that argument and actually found a case or two that seemed to suggest that, yeah, no harm, no foul, and therefore no liability under Section 549, even though there was a clear post-petition transfer that wasn't authorized by the code. So let's talk about some of the time limits. These are found in Section 546 of the Bankruptcy Code. Go ahead, Monsi.
Okay, so for a debtor in possession or a trustee to bring a avoidance action under 547 or 548 or 544, meaning the fraudulent or preferential transfer provisions, it has to start the earlier of these types of language is always found throughout the Bankruptcy Code. The earlier of, the later of 2 years after the entry order for relief, or 1 year after the appointment or election of the first trustee. So primarily it is 2 years after the entry, after the petition date. That's the most predominant deadline that comes. But let's say you have a debtor in possession and then a creditor or somebody moves to the appointment of a trustee, maybe like a year and a half into the case because the debtor's just screwing around and not doing anything for the creditors. Then a trustee comes in, that trustee would have 1 year, even beyond the 2 years. So I'm not beyond, but the 2 years will expire, but the trustee has 1 year from his or her appointment. And then, oh, go ahead. Were you going to say something, John?
No, but I will ask you a tough question after you mention the second element here, or the second factor.
So in 549 for post-petition transfers, it must be commenced an action within 2 years after the date of the transfer or by the time the case is closed or dismissed. So did you have a question about that?
So my question is, there's been development of case law over the last, I don't know, 10, 15 years that closure of a case is a ministerial act, and it really doesn't have much of an effect in terms of jurisdiction, in terms of a lot of things. So what happens if a case is closed but then is later reopened? Does the first closure cut off avoiding power claims, or does reopening the case reopen the time period in which to file these claims?
I have seen a case reopen to administer other new claims or new assets that the trustee wasn't aware of. I would think, I haven't seen it specifically for post-petition, but I would think it could be argued. I think you might still have to argue that you're within the 2 years of the petition date.
Yeah.
But I agree that trustees can reopen a case very easily because they say there's an asset that was not administered and it was not abandoned. So it still needs to be administered. I think you could argue that a claim is included in that.
Yeah, I don't know the answer. I don't know that I've seen a case deal with that.
What about tolling? Do you think you can do that?
Well, so there is some case authority for the proposition that these time periods are subject to equitable tolling. And the reason is because, as a general rule, statutes of limitation are subject to equitable tolling. So if there's been concealment of an asset that would prevent the filing of a claim or something like that, then a trustee or a plaintiff, and this applies outside of bankruptcy as well, but a plaintiff has additional time in order to file an action because the statute of limitations is deemed to have been tolled. And I don't think that these 2 year periods ought to be tolled, but there is authority for the proposition that under the right circumstances that they can be tolled, and therefore a trustee can have more than 2 years to file these actions. I think the clearly the best practice is to be sure to file the preference action or the fraudulent transfer action within 2 years after the petition date. Don't count on equitable tolling to save you. But if for some reason you've blown that 2 year deadline, take a look at equitable tolling. It might be able to get you out of a little bit of a bind. So right now, so far, all this time we've been talking about avoidance of transfers. We haven't actually talked about who you can recover the transfer from. And here real quickly, you can recover a transfer from the person who received it. You can also recover it from subsequent transferees unless they are able to raise a good faith defense. That way you can kind of chase it down the chain of ownership until you find somebody who is truly an innocent recipient of the property. And then those are the major ones that come into play. And I think that is our last slide, JP. So we
have a question in the chat. Jeffrey Kwong wants to know whether may the trustee benefit from any state law fraudulent transfer deadlines such as discovery periods, assuming the 546 has passed. I'm assuming when he puts discovery in quotes, he means sort of like the equitable tolling, where you don't discover the transfer has happened until after the deadline has passed. I mean,
also in the CCP. So you mentioned that the general rule is 4 years, but the CCP allows that to go as far back as 7 if there's been if there's been something that prevents the discovery by the creditor of the claim. So yes, I think that a creditor a trustee can use those, and usually, even though 4 years is the normal time, I'll still go back in the right case and look at 7 years and see if maybe I have the ability to go that far back.
Well, thank you, John and Monty. This has been a great presentation, a lot of ground to cover, and very informative. We all really appreciate your insight and your experience in this area. And there's lots to discuss here, and I look forward to discussing that when we get into the coffee talk at 11 o'clock. But for now, I'd like to turn it over to David Golubchik and Jonathan Weiss to go over their presentation on Chapter 11 plan confirmation issues. And then I look forward to seeing you all again in an hour. Thank you.
Thank you, JP.
Thank you.
Okay, thank you, JP. Let me figure out how to share my screen here and we'll get started. Okay, that should do it. Okay, so good morning. Along with my friend David Golubchik of Levine, Neal, Bender, Yu, and Golubchik, I'm Jonathan Weiss. I'm a bankruptcy and restructuring partner at KTBS, and we're delighted to be here to present on certain key plan confirmation requirements in Corporate Chapter 11s. Of course, it goes without saying, but the statements and opinions in today's presentation are those of David and myself individually, and don't represent the views or opinions of our firms, our clients, or anybody else. So before we get to the specifics of plan confirmation, we thought we'd take just a few minutes to take a step back and just provide some context on how exactly a case arrives at the plan confirmation stage. So you've heard yesterday about the process of filing a Chapter 11, filing and prosecuting first day motions, obtaining DIP financing. You've also heard about 363 sales in bankruptcy, but eventually a debtor would like to exit bankruptcy. And generally, the way to exit a Chapter 11 is to file and confirm a Chapter 11 plan. Now, the plan can be a reorganization plan. For example, it contemplates the debtor continuing in business as a reorganized company, hopefully with a leaner capital structure, maybe improved operations. Or it can be a liquidation plan, which you'll typically see after a 363 sale, where the assets were quickly sold and the estate now has a pot of cash. And the plan contemplates taking that pot of cash and distributing it. So in any event, the plan is essentially a big contract that sets forth what's going to happen and who will get what. And along with that plan, the debtor will file a plan and a disclosure statement. And the disclosure statement is a long document that must, pursuant to the Bankruptcy Code, Section 1125, contain adequate information, which in practice means telling people about the debtor's history, operations, events leading to bankruptcy, events taking place in the bankruptcy, a summary of the plan, and most importantly for today's purposes, why the plan is compliant with certain critical confirmation requirements. And the reason you need to provide the information is because creditors who are impaired will have the opportunity to vote to accept or reject the plan. And David's going to tell you all about class voting and classes in just a couple minutes. So the debtor files the plan and disclosure statement and then proceeds to get court approval of that disclosure statement. And assuming the court gives the debtor the go-ahead, the court will also set deadlines for creditors to vote on the plan, and the debtor will go ahead and mail out the plan, which is known as solicitation. Parties can object to the plan. Often an objection will be on one of the grounds we'll cover today. And the debtor will respond to any such objection by filing a confirmation brief, which will set forth why the plan satisfies the relevant requirements of Section 1129, and which will respond specifically to any filed objections. The court will hold a hearing, and hopefully, from the debtor's perspective, it hopefully will confirm the plan after considering whether the plan does, in fact, satisfy the elements of 1129. And among those elements are four major issues that we'll be discussing today.
Class voting. As an intro to the class voting, a practical pointer, while plan reorganization is your exit strategy, preparing for the plan does not come in the middle or the end of the case. In my view, preparation for a plan should commence prior to the bankruptcy being filed. So when I interview a potential client, as they're talking and the questions I'm asking, I focus and try to figure out what are my classes, and most importantly, what will be my impaired consented class for the plan, because I want to have a sure thing for the exit rather than dealing with uncertainties. So let's get into class voting. Next. So as Jonathan said, you need to have a plan that's approved by the court in order to reorganize. liquidate whatever your plan provides. In order to do that, you need to have classes of creditors vote in favor of your plan. And the question is, what are classes? Classes, let's move to the next slide. Class voting, introduction, how they're organized, how do they vote, what do you need for confirmation and designation of votes. Let's go to the next one. How are classes organized? So classes are organized based on similarly situated creditors. Generally, secured creditors have unique rights. For example, even when you're dealing with the same real property, the first lien holder will have different rights than the second lien holder. So generally, each secured creditor has its own class. Usually, unsecured creditors are pooled in one big class, which is the general unsecured creditor class. And that often happens with deficiency claims of secured creditors. So there's a Ninth Circuit case called Johnston, 21 F3D 323, Ninth Circuit 1994, which discusses the classification similarly situated, same kind, species, and the character of the claims. And then you have the Barakat case, which is 99 F3D 520, Ninth Circuit 1996, that also says that creditors' deficiency claims fall into that category, which kind of brings me to the initial comment I made. When you're looking at a potential Chapter 11, you need to analyze what the claims are. If you anticipate that unsecured creditors will support your claim, but you have secured debt, which is underwater, there's going to be a deficiency that may trump the unsecured creditors. So all these analyses generally occur prior to the bankruptcy to prepare for it. Let's move to the next one, to the exception. So generally, similarly situated creditors have to be in the same class and they vote together. However, in certain circumstances, courts allow separate classification of otherwise similar claims. For example, when there's a legitimate business purpose, when there's no other alternative, when separately classifying certain claims is going to result in maximum recovery to the creditors. And Judge Barish has a published decision called Rexford Properties, 558 BR 325 from 2016, that specifically discusses in unique circumstances, you can separately classify otherwise similarly situated creditors because but for the separate classification, everyone else suffers. So there has to be a purpose. However, gerrymandering, where you separately classify creditors to benefit the voting and no other purpose, is not permitted. And that's discussed in detail in the Johnston case that I mentioned. Next tab. So the question is, who's entitled to vote? Only impaired classes are entitled to vote. Impaired classes are those whose legal interests are altered. Usually people think it's altered to the negative. If you improve someone's position, increase their interest rate, that's also alteration. That's an impaired class, which can go in a different good faith discussion. But impairment is any treatment that's different than the contract terms. If you have a class of creditors that's being paid in full, they're deemed to have accepted the plan, they don't vote. If you have a group of creditors or equity holders that get nothing, they're deemed to have rejected the plan, so they don't vote. Only those that are affected get to vote. Next one, what is an impaired class? I discussed this briefly just a moment ago. If it's impaired unless its interests, legal, equitable, contractual, are unaltered. There's a good discussion of that in a case called L&J Anaheim Associates, 995 F2D 940, 9th Circuit, 1993. Also, the Rexford case that I mentioned earlier from Judge Barish has an interesting discussion. In that case, we had vendors whose continued services were critical to the debtor. So the debtor proposed a plan which pays everybody 100%. However, in order for them to receive it, they have to continue to do business with the debtor on terms that are at least as favorable as pre-petition. So although on the one hand, they're being paid in full and they could be deemed to have accepted the plan, so they don't vote, because there's a change in contractual rights, meaning they have to continue to provide services, it is deemed impaired and they get to vote. The other issue at the bottom is the exception. Impaired classes are those whose contract rights are changed by the debtor or by the plan. If the bankruptcy code changes the contract rights, that is not impairment. So the example on the bottom is 506 BC, which are landlord claims. When executory contracts leases are rejected under the bankruptcy code, there's a cap on the claims. The cap will be less than 100% of the debt, but because this cap is provided for under the code rather than the plan, the claim is deemed unimpaired. And for that discussion, if you want, you could look at a case called PPI Enterprises 324 F3rd 197, 3rd Circuit 2003. So now next tab, please. Okay, what is a yes vote, an accept vote in favor of the plan? You need to have at least over half in number that vote and at least 2/3 in dollar amount. Earlier, I told you secured creditors generally have their own class, which means there'll be one vote. You will have 100% yes or 100% no to the extent that they do vote because they're impaired. When it comes to the unsecured classes, you need 2/3 in dollar amount. So if you have $1 million in claims, you need 667,000 and more than half in number of those that vote, not total creditors. Let's move on to the next one. Then we have a concept called designation of votes. Here, if a creditor is deemed to, is viewed to have voted, not in good faith to recover the debt, but for some ulterior purpose, the court can designate its claim, so it doesn't count. It's basically a lack of good faith argument. There's a case called DBSD North America, 634 F3rd 79 out of the 2nd Circuit in 2011. There, the owners of a competitor bought out claims and voted against the plan. The court made a finding that this is for a competitive purpose and not for purposes of collecting the debt, the claim. As a result, they were not allowed to vote, so their vote didn't count. Next tab. And this is the conclusion. So for purposes of the claims, you look at similarly situated claims. Generally, you have secureds. Each secured gets its own claim. Unsecured is pulled together. Equity is pulled together in most cases. Now, if you have preferred common stock, that could be broken out. But again, you look at the legal rights. Only impaired classes can vote. And you need, to the extent they are impaired, you need 2/3 in dollar amount, 1/2 in number for a yes vote. And for lack of good faith, the court can designate a vote, so it does not count. And you generally need all classes to vote, except to certain cram down exceptions, which we'll discuss in a little bit. You're up, Jonathan.
Thank you, David. So that takes us to the next of our big four issues, namely feasibility. So once you have your classes, as David discussed, and hopefully you have enough class, you've got your requisite acceptances, so you've got your impaired consenting class, you have some other requirements as well. And so let's begin with the basics of section 1129A11, which is feasibility. So that section requires the confirmation of the plan is not likely to be followed by the liquidation or the need for further financial reorganization of the debtor or any successor to the debtor under the plan, unless that liquidation or reorganization is proposed in the plan. So what does that all mean? In a nutshell, these are nuts and bolts after all, the debtor needs to make a showing that whatever the plan provides as far as its mechanism or mechanisms to effectuate the exit strategy, that mechanism has a reasonable shot at working. Now, what might those mechanisms be? Let's back up. Every Chapter 11 plan is different, but they all have some similarities. They generally begin with an introduction or an executive summary. Perhaps they'll contain a section, well, they'll all contain a section describing each class, and that which David has expertly explained, and providing information regarding the plan's treatment of each class. So for example, the plan might say, class 1 consists of a secured bank loan. That class will receive a new loan. That class will retain its lien. Class 3 might be a group of bondholders. Maybe the treatment for the bondholders is some sort of combination of take-back debt and some equity in the reorganized company. Maybe there's a class 6, which is general unsecured claimants. Maybe they're slated to receive a pro rata share of a finite pool of cash. Then the next section of the plan, most importantly for our feasibility discussion, is generally called means for implementation. And this is where the debtor describes what sort of transaction or transactions it will enter into to allow itself to exit bankruptcy and make good on the treatment that it's promising to its various classes of creditors. Now, this can take the form of a debt to equity conversion. It can have some sort of exit financing. There could be an equity rights offering. It can be any combination thereof, or in a liquidating plan, it can simply state that all the debtor's assets will be going to a liquidating trust or some sort of plan administrator who will distribute that cash or those assets. And this is all in section 1123 of the Bankruptcy Code, which we'll just mention in passing. It's called the contents of the plan, and it mandates that the plan shall provide adequate means for the plan's implementation and provide some examples, which we're not going to get into right now. But the point is, the Bankruptcy Code needs to ensure, and the debtors need to prove, that whatever the debtor's goal is for means of implementation, those means are sufficient to allow the debtor to operate without the need for further liquidation or reorganization. And as we have on the slide, as the court in W.R. Grace out of Delaware makes clear, the debtor has the burden of proof on this inquiry and must show by a preponderance of the evidence that a reorganization plan is feasible.
Oh, Sasha, it doesn't want to eat anything. Judge Klein is a weirdo.
I think somebody is not on mute. Thank you. Going on to the next slide, the question then becomes, how difficult is the burden? Well, a debtor need not guarantee success, nor could anybody ever guarantee success. So the burden falls somewhere below that. The Delaware Bankruptcy Court has found that the Bankruptcy Court need not require a guarantee of success. That's in, again, W.R. Grace. It's in Indy Downs, plenty of cases. But rather that the plan presents a workable scheme of organization and operation from which there may be a reasonable expectation of success. So we're looking for a workable scheme, a reasonable expectation. Sure, you might have a chance of failure or a chance of uncertainty, but courts have stated that the mere prospect of financial uncertainty cannot defeat confirmation on feasibility grounds. And plenty of courts have agreed with this approach. So we're basically looking for a reasonable, workable prospect of success without any guarantees. We're trying to avoid, as the Court of Appeals in the 10th Circuit has said, we're trying to avoid visionary schemes which make promises to creditors and equity security holders that are more than the debtors could possibly obtain after confirmation. Now, moving on. What does the court look to? How does a court determine if a plan is feasible? So number one, the adequacy of a debtor's capital structure. What does the post-effective date capital structure look like? Is the cap structure leaner than it was when the debtor filed? How much debt's going to be on the reorganized company? What are the interest rates? What are the maturities? All of these things have an important impact on the debtor's viability moving forward. Next, the earning power of the business. Is the business viable? Have changes been made to the operations to fix any problems that may have contributed to the filing? Remember, this is a company that filed for bankruptcy, weeks, months, maybe a year or two ago. There was a reason for that, and perhaps the reason had to do with the operations. What did the debtor do to fix that? Perhaps the debtor sold or closed an unprofitable business line. Maybe underperforming leases, if this was a retail chain or a restaurant chain. Maybe underperforming locations were closed or leases were renegotiated. Maybe, unfortunately, there was a reduction in force. All of these things will impact the debtor's earning power going forward and will have an impact on feasibility. Next, economic conditions. This looks to external forces, and this was a big deal during the early COVID days. A business can have a lean capital structure, it can have a dynamite business plan, but if you run a restaurant chain in California, and California has ordered all restaurants to be closed indefinitely because of a global pandemic, you're not going to make any money. So the court's going to look to external factors as well. Number 4 and number 5, which are related, the ability of the debtor's management and the probability of continuation of the same management. Who's running the show? Is it the same person who brought the debtor into bankruptcy and the debtor may have complained about in the first day declaration? Usually not. Is it somebody new that was brought on that has a plan to transform the company? And if so, if you have a new management team that's well credentialed, are they incentivized to stay? So courts will also look to the management team, which has an important hand in guiding the business and ensuring profitability going forward. And finally, number 6, any other related factors.
Okay, before we move on, there was a comment or a question inside the chat. If you could open up the chat, Jeffrey, and take a look at that question.
I think that was for John Tedford earlier, the earlier program.
Oh, got it. Okay. Sorry.
Hi, Leslie indicated to me that my microphone might be fading in and out. Can people hear me?
Yes.
Okay. If that happens again, Leslie, just let me know again. So moving forward, now that we know what a court is looking to in terms of feasibility, how does a debtor go about proving that? So the question is how a debtor convinces a court that those factors are satisfied. Now, it takes more than a lawyer writing some flowery brief attesting to the robust earning potential. It takes more than a lawyer standing up in court and telling the judge that the debtor will make a lot of money, because notwithstanding what we bankruptcy lawyers often think, lawyer argument is still not evidence. So instead, a good lawyer will introduce some actual evidence, either in the way of a written declaration that's submitted to the court, perhaps a lawyer standing up in court and offering a proffer, which is telling a court what a witness would say, and then offering that witness for cross-examination, or putting an actual witness on the stand. And what kind of evidence or what kind of witness would be useful? Well, feasibility can be established through the testimony of experts and those knowledgeable of the future prospects of the business. For starters, a financial expert might provide evidence regarding adequate capitalization and expected cash flow. Very important in this regard is that the debtor, well, I keep saying debtor, but really it's the plan proponent, demonstrate that there's adequate financing lined up. Perhaps you attach an exit financing term sheet. There should be a go-forward financial analysis. The plan may include go-forward pro forma projections. Now, there might be testimony regarding industry or economic conditions, perhaps some evidence regarding the effects of significant claims against the debtors and the likelihood of those claims actually being allowed. I was involved in a confirmation hearing some time ago where there were very large priority claims that were asserted against the debtors. And my recollection is that we introduced expert evidence at the confirmation hearing regarding the expected value of those claims. And that was sufficient for the court to find that the plan was feasible and had a reasonable expectation of success. Again, we didn't promise to the court that our number was correct, but we introduced admissible evidence in the way of expert testimony, tending to show that the plan was workable. Now, again, as we've discussed what issues a court might look to and what types of evidence a debtor might introduce, what does the expert evidence focus on? Well, as we discussed earlier, you'll want to show why a company that was troubled enough to file for Chapter 11 protection will be able to make its way on its own after bankruptcy. And as we discussed before, the evidence might discuss any of the following: a right-sized capital structure, a reduced physical footprint, maybe there's rejected leases, renegotiated leases, increased liquidity, do you have exit financing, elimination of unprofitable business segments, or reduced interest expense, or any other factor that will make it easier for the debtor to operate and will affect a change from what was the situation prior to bankruptcy. So until now, we've been discussing feasibility in the reorganization context, but as discussed earlier, a debtor's exit option could revolve around a liquidating plan, in which case, rather than contemplate a continuing business, the plan instead contemplates winding up the debtors and distributing assets to stakeholders in compliance with the waterfall set forth in the plan, and hopefully the bankruptcy code. You'll often see this after a Section 363 sale when the estate is sitting on what's essentially a pot of cash. So in this scenario, financial expert testimony, fancy projections, far less necessary and far less relevant. Instead, a plan proponent needs to show that there is sufficient cash to make required payments under the plan, and principally payments to administrative and priority claimants, which need to get paid in full. Now, it's simpler, but not always as simple as it sounds, as there could be situations where you have large claims entitled to priority, and those claims may be disputed, but the dispute hasn't been resolved at the time of plan confirmation. And as discussed earlier, you're going to need to show by some way that those claims are not going to derail the ability of the debtor to make required payments. So that concludes the theory portion of the feasibility discussion. Now, I just want to spend a couple minutes showing some real world examples. First of the debtor's feasibility case in chief, then of objections, and finally of court opinions determining whether a plan is or is not feasible. So here on this slide, we have feasibility testimony from a financial expert who draws on the debtor's exit financing, both a revolving loan and a term loan. And the expert tells the court that it's my conclusion that the funding available from cash on hand and other sources of cash should be sufficient to allow the reorganized debtors to satisfy their obligations under the plan, repay and service debt obligations, and continue the operations on a go-forward basis. Perfect. Absent objection or the court's own further analysis, that provides the court with perfect evidence and an evidentiary basis to find a feasible plan. Other testimony. This slide provides two other real-world examples in respect of other feasibility issues. In other words, aside from dealing with inadequate post-emergence capitalization. First, we have a CEO testifying to the debtor's future performance and right-sizing a retail debtor's store occupancy costs. Stated differently, the driver of distress for this company was a footprint that was just too big, and that was fixed during the case, and the CEO has now told the court that the company's lease portfolio has been right-sized. The second quote on bottom is from a company's controller. This was in the context of a case that had several large and troublesome claims that would have needed to be paid. After analyzing each of the claims, the controller offered his testimony that none of the claims would ultimately result in liability to the debtor. This doesn't, of course, knock out the claim. The claimant has every right to pursue the claim and seek allowance, but it did suffice to obtain plan confirmation in this case. So the point here is that depending on what your driver of distress might be, or depending on your circumstances, your feasibility analysis and evidence might be different. Now, how does a debtor prove feasibility aside from expert testimony and declaration? Well, this is another tool in the debtor's playbook. And I'm sorry for this small print here. We're used to, when we're in person, we're on a big projector screen. But these are financial projections. Here, the debtor provided to the court a projected statement of profit and loss, showing projected revenues, EBITDA, and net income, among other things, for 4.5 years post-emergence. Not surprisingly, the projections show the debtors making ever-increasing amounts of money. You typically won't see the opposite, as that would be Exhibit A against confirmation. You'll, of course, want to have some basis to have made these projections, but in any event, this is the sort of thing a debtor will present to the court to help obtain confirmation and helps prove feasibility. Just a couple examples now of objections, the parties objecting to feasibility. Well, here's one example. So remember earlier we discussed how economic conditions and external factors like COVID might impact the ability of a debtor to prove feasibility. Well, here's an example of a creditor latching onto that. Evidently, the debtor had included projections in a February 2020 disclosure statement. And we all know what happened in March of 2020. And then the debtors updated their projections to make them far less rosy. So naturally, a creditor called him out on this, pointing out that the new projections were far less optimistic and that the COVID pandemic required that all the parties essentially go back to the drawing board. Now, I wasn't involved in this case. I don't know how this particular argument eventually shook out, but we're including this as an example of how somebody might object to feasibility when it has an issue with the viability of the debtor's projections. One other example of a feasibility objection, a bit more of an esoteric one, but apparently this debtor's plan called for, as part of its means for implementation, some sales of mines and the related permits. And this objecting party argued that the proposed sales were not in compliance with applicable regulations and thus would not be able to be executed, thereby undermining, no pun intended, the feasibility of the plan. After all, if a plan is based on a sale or sales that can't be closed, the plan will just not be successful. And this creditor made that point. Finally, once we've seen examples of real-world debtor evidence and objector objections to feasibility, just a couple slides showing how courts have determined whether a plan is feasible. And this is the next slide, give examples of when a court has denied confirmation on feasibility grounds. Now, truth be told, courts far more often find plans feasible, particularly as most plans, by the time they're presented to the court, are consensual. So we thought it would be a lot more interesting and fun to show a couple examples of denials. And the first one, in a case called Paragon Offshore, dealt with the court's rejection of the debtor's financial models as not reasonably achievable. And the court instead found that the debtors are likely to run out of cash and therefore breach their financial covenants and be unable to pay their debts, and that they're unlikely, to be able to refinance their indebtedness to the term lenders, the revolver lenders, and the note holders prior to maturity. In other words, the court was not convinced the debtor would be viable, and the court instead was convinced that in all likelihood, the debtor would be either back in bankruptcy court or would liquidate. Precisely what Section 1129A11 seeks to avoid. Finally, one final slide in this segment, in the Las Vegas monorail case from nearly a decade ago, in which a court on its own, and despite contrary testimony from the debtor's expert, found that the current plan dooms the debtor to failure, as it grossly underfunded the reorganized debtor's needs and contemplated losses for the next 7 years. So again, the court concluded that the debtor had failed to show this reorganization is not likely to be followed by the need for further financial reorganization. So that's all for feasibility.
Jonathan, let me ask you a question.
Sure.
It's great you talk about all these experts, financial experts, restructuring experts. I think the reality is on the West Coast, the Chapter 11s are substantially smaller than, Texas, Delaware, New York. If you have a smaller case where you don't have the financial ability to hire all these top experts to help you with feasibility, do you have a chance of getting a plan confirmed?
Well, I think, the code says what the code says, and I think you still need to have some sort of financial basis. Perhaps it's the company's CFO or some other person at the company with that sort of expertise who's got to show the court some evidence regarding financial wherewithal. So, perhaps you're not hiring, outside financial advisors or an outside investment banker. But and that was one example we showed CEO testimony. I think you're going to at least need somebody maybe within the company who's got financial expertise to show the plan, lowercase plan, going forward, and why it's attainable and achievable.
Got it. Before we go to the next section, I just want to add one thing. So, in my view, feasibility and the issues that Jonathan discussed are probably the most important issues for plan confirmation. At the end of the day, while you deal with the different classification, technical issues of the bankruptcy court and the code, the question is, can this plan survive and can this happen? So feasibility is critical. You have a bunch of experts, financial experts, projections, valuations, providing the testimony. But how is all this presented to the court, and assuming that you have objecting parties, how do you deal with cross-examinations and all those issues? You as the attorney have to become an expert in all those fields. And some of them are kooky and things that we may not be used to on the West Coast, but the only way this gets to the court and for you to address the other side is you effectively becoming an expert of your own. A few years ago, my partner and I were involved in a case in Texas that had to do with helicopter transportation company to the oil derricks in the Gulf, where you had to deal with oil technical data, helicopters, planes, and valuations relating to it, something that generally over here you don't deal with. And it is really complicated, difficult, time consuming, I think, for an attorney to become an expert in all of the testimony that the hired experts are going to provide and to address the other side. So just wanted to throw that out. Should we switch over to Cramdown?
We should. Thank you, David, for that added perspective. And let's move on to Cramdown now.
Okay, so earlier I discussed that you need to have votes of classes of creditors to confirm a plan. Generally, for a consensual plan, you need everyone to vote yes. But the bankruptcy code has a cram down provision. And what that means is If you have a class of creditors that do not vote in favor of your plan, so it's not consensual, under certain circumstances, you can still confirm the plan by cramming it down that dissenting class's throat. I'm not sure if the code says throat, but that's what it is.
It does not.
So in order to be able to use this cram down alternative, and again, it's something that you need to think about even before the case is commenced to plan this out, you need at least one class of creditors that is impaired to vote in favor of the plan. So everyone talks always about what's your impaired consenting class. That's this issue. Assuming that you can have an impaired consenting class, you are able to cram down on dissenting creditors, assuming that you show two things. One, the plan does not unfairly discriminate against the dissenting class. And two, the plan is fair and equitable as to the dissenting class. Next tab. So intro, when is the plan unfairly, does it unfairly discriminate? And when is it fair and equitable? Let's move to the next one. So unfair discrimination is when you treat, if classes within or claims within the same class are treated differently without a reasonable basis. And the various approaches here there are three: the restrictive approach, the mechanical approach, and the broad approach. Next tab. So if you have one class which is similarly situated or higher than another class being dropped to a lower level, subordinated, that's the restrictive approach. It's relatively simple. You have the In re Martin case from Montana 1986 on the tab. Next one is the mechanical approach. This has to do with the gerrymandering. When you put creditors that are otherwise similarly situated in different classes to treat them differently. We have the gerrymandering discussion where you cannot gerrymander unless you have a specific reason to do so, which I discussed in the prior category. However, there's another case, this is the Greystone case at the bottom, where you provide for different dividends in the same class. So for example, you have a class of total claims $1 million. Some have claims of $1,000, have some 10,000, and the plan provides that everyone's going to get $500 on account of their claim. While the amount is the same, the percentages are different because $500 payment on a $1,000 claim is different than a $500 payment on a $10,000 claim. So you cannot treat people and classes, claims within the same class differently. And then you have the broad approach, where you look at the big picture. You look at whether there's a reasonable basis, whether you can have a plan without discrimination or discrimination is necessary, whether you're proposing this in good faith as opposed to penalize a creditor that you have had a hard time with, and whether there's a proportionality to the rationale. So, for example, you have a case where you need certain trade vendors and they will not provide services to you but for this confirmed plan. You cannot get these services from somebody else. Very often this is applicable in such industries as the automotive industry, where you have one supplier of certain parts or supplies. Then under certain circumstances, you can have separate treatment, which is not viewed as unfair discrimination. And again, this overlaps with the classification discussion previously. Now, when we get to the secured creditors and discuss fair and equitable, that's the next tab, you want to make sure that they have the present value of their claim. If you have a $1 million debt on a $500,000 piece of property, their secured claim should be for $500,000, not for $300,000 or a different amount. They have to get the present value of the claim. And then you get into valuation issues here. You can have a property that is used as, a skilled nursing facility where for purpose of plan confirmation, you have to value it for the purpose it is intended in the plan. So if you have an objecting creditor that views this as some sort of a hostel or something else and tries to value it at a different amount, that's not permitted. You have to value it for the purpose that it is being used. Next tab, please. So 506A discusses the valuation that I just mentioned, present value of the collateral. You have this Sunny Slope housing case on the bottom where there was a dispute as to how the property is going to be valued for plan confirmation purposes, and the court made a proper finding. You value the way it is being used, not pick and choose, which value is higher, which value is lower to move forward. Next tab, please. Oh, yeah, we're there. Okay. Next is the interest rate. That's always a big fight in connection with plan confirmation. What interest rate do you give a secured creditor? There are several approaches. One, everyone discusses the Till case, which is, well, I guess we can switch to the next tab. Supreme Court case out of 2004. I mean, it's interesting. A lot of our laws and from the Supreme Court don't originate from Chapter 11 cases. Till, I believe, was a truck in a Chapter 13 case, but still applicable. So in the Till case, you look at the court made a finding that you have to start with some certain measure. And the court there said, let's start with the prime rate. And then we have to add to the prime rate the risk associated with the loan, where you look at the property, you look at loan to value, the condition, the economic markets, and generally the Till standards that a lot of people have used are prime +1 through prime +3. With low interest rate, prime +3 is still a really good deal for properties. Now, Till has a footnote, it's footnote 14, which says, if there is a market outside of the bankruptcy world that could be applied, you look at that. Many courts, and we have the Texas Grand Prairie case, say that there are no such markets, but that's the experts that Jonathan was talking about earlier. The experts can tell you there are markets for anything and everything with appropriate interest rates. So we have to have evidence for the court, and the secured creditor presumably will have something else to show that your proposal is different. But assuming that you are able to get the court to sign off on your proposed interest rate, and you have under 506 the present value of the lien, meaning the secured debt, you're in good shape for cram down. Let's go to the next tab. Next tab is sorry, I'm jumping the gun by kind of moving forward on this. It discusses the market rate of interest if there is a market for non-debtor transactions. And very often the arguments debtors make is there is no market outside. That's why we're in bankruptcy. Follow the prime +1, prime +3, and adjust it subject to those three elements in the bottom: length of the payout period, quality of the creditor's security, risk of subsequent defaults to the current risk-free rate for similar loans. Let's go to the next one. The next is this prime plus that I discussed, and it has the three considerations, which are effectively the same as when you're looking at the market itself. You just look at the quality of loan and the collateral that you would provide outside of bankruptcy. Now let's move to the unsecured creditors. For creditors in an unsecured class, in order for a plan to be fair and equitable, it actually is really simple. One is the class gets the amount of its claim. which generally does not happen. Option B, if that doesn't occur, a junior class receives nothing. And that's generally the position. A junior class doesn't get paid until the senior class gets paid in full. And what happens often is, especially in the smaller cases, you have your secured debt, let's say class 1, maybe another secured debt, class 2, you have your general unsecured pool in class 3, and then you have your equity in class 4. You cram down on that secured creditor class, and obviously you're not going to pay them the amount of the claim, so you will eliminate any distribution to class 4, the equity class. That's all you need to satisfy the fair and equitable requirement for a cram down. Now, there are other aspects here, such as new value contribution, where equity or somebody else contributes value to, because at the end of the day, you need to have equity as part of a company. But for purposes of fair and equitable, that suffices. And the final one is the conclusion. As we already discussed, plan unfairly discriminates if it treats similarly situated classes of creditors differently without a reasonable basis. The reasonable basis is the broad approach discussed earlier. And it's fair and equitable if the secured creditor gets the present value of its claim, meaning the value under 506, an appropriate interest rate. And as to the unsecureds, generally the lower class, usually the equity class, does not receive a distribution on account of this plan.
Thanks, David. That was really interesting, and I'd always known of the importance of TIL in obtaining leverage against lenders and cramming down secured creditors. But one thing I learned from reading the recent book about the Caesars bankruptcy, which is I highly recommend to everybody, is that apparently the word TIL is now used as a verb, as in an equity sponsor telling its lenders, "I'm going to TIL you," as a threat. So learn new things every day.
Nice.
So moving on to the best interests of creditors test. So you're almost there, everyone. If we were in person, this is the part where everyone is checking their watches. We're almost there. So once again, starting with the basics, what is the best interests of creditors test? So section 1129A7 of the Bankruptcy Code requires that each holder of an impaired claim or interest that doesn't vote to accept the plan receive or retain under the plan, on account of such claim or interest, property of a value as of the effective date of the plan that's not less than the amount such holder would receive or retain if there was a liquidation under Chapter 7. So what does this all mean? So essentially the code, as the slide shows, protects non-consenting members of impaired classes by ensuring that they're not going to do worse under this plan than they would have done if there was a Chapter 7 liquidation. Two really important points at the outset. Number one, this only applies to impaired classes. Now, recall David's discussion earlier about classes. If a class is not impaired, meaning its legal and equitable rights are not being altered, it does not, in theory, need the best interests test. So we're only dealing here with a class whose rights are being altered, a class that's impaired. Number two, and critically, this section protects claimants or interest holders on an individual basis. So even if a class of claims or a class of interests accepts the plan, in other words, as David explained, they have the requisite amount and number of claims that have voted to accept the plan. If a particular creditor within an accepting class rejects the plan and the plan fails the best interest test, the plan may not be confirmed. Now, what is the best interest test? Well, Collier's, the most important bankruptcy treatise out there, calls it one of the cornerstones of Chapter 11 practice, and that it guarantees to each creditor that it will not do worse under whatever deal the debtors negotiated, whatever deal is being implemented in this Chapter 11 plan, than it would have done if there was no plan or no means at all, but there was just a liquidation. In other words, there's a basic threshold in bankruptcy practice or in Chapter 11 practice that nobody can do worse than a Chapter 7. Beyond what you get in Chapter 7, beyond that threshold, fine. That's subject to negotiation. That can be approved by class acceptance on a class level and then imposed unilaterally on individual dissenting members of that class. But the basic threshold, which is that you cannot do worse in a Chapter 11 than a Chapter 7, that's a guarantee to each individual creditor or individual interest holder. Oh, excuse me. So again, how does a plan proponent satisfy the test? Unfortunately, again, it's expensive. You're using financial evidence and financial testimony. Just like feasibility, you've got to prepare a liquidation analysis to show the liquidation value of the debtor's assets. Or stated differently, the value of the debtor's assets if they were liquidated in Chapter 7. So the debtor will often prepare and file a liquidation analysis comparing projected recoveries under the plan on the one hand with projected recoveries in a Chapter 7 on the other hand. And we'll take a look at some of those as they've actually been filed in a couple of minutes. Note, though, that in calculating the value of the debtor's assets in a Chapter 7 liquidation, there could be a difference of opinion whether the liquidation values should be at fire sale conditions or orderly liquidation conditions. Meaning, if you're orderly liquidating, perhaps you're spending more time to finding the best value. Values could be a bit higher. If you're assuming fire sale conditions, then you're just selling everything as fast as you can, and you may have to accept some pretty depressed values for your assets. And the materials cite a Delaware case speaking to that issue. Naturally, plan proponents will want to use values under fire sale conditions, as this will result in a lower valuation and make a lower hurdle for plan recoveries to satisfy the best interest test. But in any event, regardless of which value is used, the liquidation analysis is a central document in any reorganization plan and will almost always be included together with a plan or a plan supplement. Now, the liquidation analysis is not a carbon copy in every plan. It has some nuances and some sources of uses of cash that wouldn't exist in a Chapter 11. So for example, perhaps in a Chapter 11 plan, which contemplates a reorganization or which is liquidating following a Section 363 sale, many leases and contracts are being assumed or assumed and assigned because the reorganized company needs these contractual relationships to be a viable business. But in a Chapter 7 liquidation, there's nothing to reorganize and save. So the Chapter 7 trustee would presumably reject all of the contracts or leases, or almost all contracts and leases, which would give rise to rejection damages claims. So that could increase the pool of unsecured claims in the Chapter 7. Second, in a liquidation analysis, must estimate recoveries from estate causes of action, like you heard an hour ago in the avoidance action session. Perhaps the estate has avoidance claims. These are often buried in Chapter 11 reorganizations and sales because a go-forward company is not going to want to emerge from bankruptcy and all of a sudden sue its important vendors to recover preferences. So it will agree not to pursue those. But in a Chapter 7, that's not a consideration. A Chapter 7 trustee is going to pursue those. So a liquidation analysis should take into account any such potential recoveries. And finally, a liquidation analysis should take into account additional fees that would be owing to a Chapter 7 trustee and the trustee's professionals that would be engaged upon conversion to Chapter 7. So this is not an exhaustive list, just some examples of areas where a Chapter 7 waterfall might differ from that in Chapter 11. The next 3 slides, I've just got some examples of liquidation analyses to just give you a sense of what these look like. This slide we're showing now, you can see in the top left, there are 3 columns. The value of assets as of October 25, 2019, then the estimated value that you can get for those assets in the Chapter 7, and then the estimated value you can get for the assets in the Chapter 11. So for example here, one of the rows shows value to be received through the plan of reorganization. So in a Chapter 11, the debtor contemplated receiving $750,000 under their plan. In a Chapter 7, that would simply not be possible. It's unknown, which gives you a lot more cash, a lot more assets to work with in a Chapter 11. And using that, now going to the bottom right of the screen, the debtor showed proposed recoveries under the Chapter 7 analysis and under the plan. And as you can see here, even though general unsecured claims were only slated to receive between 1/4 and 1/3 of their claims under the plan. In a Chapter 7, it was a lot uglier. Another couple examples of what these look like, and we'll just go through these slowly as we're running out of, quickly, excuse me, as we're running out of time. Here's a case I worked on several years ago. Again, you're looking at cash and cash equivalents and what the value is of those, accounts receivable, inventory. You're going through all of your assets, and it's showing the court what these are worth if you're going to have to liquidate. And using that, then you're going through your various classes of claims. So you've got your DIP claims, which here were $0, but you've got your term loan claims, which were $88 million. And you're showing what percentage recovery that class of creditors would receive in a Chapter 7. And in this instance, the projection was between 21% and 27%. And then for any other claims, it's 0% because the term loans used up all of the available cash. And in that case, it's not here on this screen, but in that case, the Chapter 11 recoveries were far higher than what's shown on this screen, which was the basis for us telling the court that we've satisfied the best interest test. Here's one more from a case we're involved in now.
Wait, go back to the last one. Did you just put that you guys aren't getting paid anything in a liquidation? I thought I saw administrative claims get 0. No?
Yeah, that's this is one of several entities. There was another entity which was the OPCO, which had some more money there.
I was wondering, how does attorney propose such a plan?
There was this was the parent.
All right.
There was an OPCO which looked different. This was a more straightforward example, but good catch. First rule of lawyers is make sure there's money for professionals.
Exactly.
Here's just one more, and you can take a look at the materials on your own time. I'm not going to go through this right now as we're running out of time. The final point I just would want to make, and we'll skip the last couple of slides. The final point is that there could be some differences in a liquidating Chapter 11. Because again, the liquidation analysis compares the Chapter 11 plan to a Chapter 7 liquidation. So the question is, what if you're liquidating anyway? Presumably your recoveries would be pretty similar to a Chapter 7, but there still needs to be a showing that this test is satisfied, but it's usually a lot simpler. And oftentimes the analysis will simply turn on some of the things we mentioned earlier, which is that if you're in Chapter 7 and you're liquidating, your liquidation is perhaps quicker and at fire sale values, as opposed to a liquidating 11, which may provide for an orderly process. If you're in Chapter 7, perhaps you're paying additional fees to the Chapter 7 trustee. There are various items which can lead to, number one, increased expenses in a Chapter 7 as opposed to a Chapter 11 liquidation, and a larger claims pool in a Chapter 7 as opposed to a Chapter 11 liquidation. There are some potential complications. You can take a look at the slides. I'm not going to get into those now as we're running out of time, but that is liquidation analysis and best interest in a nutshell. And I think that that concludes our presentation.
JP, you're up.
Thank you, David. Thank you, Jonathan. Are there any questions from the audience? All right. Well, if we don't have questions, I guess that means that you guys covered everything so thoroughly that there's nothing left to ask.
Or everyone's sleeping.
Or it's the last presentation of the day, and
Yeah. Well, thank you again very much. Let's see. Here we have a question from John Tedford, who asks, Jonathan, are you in favor of the per debtor or per plan method?
Well, as someone who fancies himself a debtor's lawyer, it's a lot easier if you're doing this on a per plan method. This is something that I spoke about at an FLC program a couple of years ago as perhaps one of the benefits of filing in the Ninth Circuit as opposed to elsewhere. But if you're doing it on a per debtor method, if you've got a large group of debtors, it certainly makes it a lot more difficult.
Considering myself a dyed-in-the-wool debtor's attorney, I agree with you. So, all right, well, now we have a little bit of time for closing remarks until we get into our coffee talk, and I won't take too much time because I'm sure everyone wants to speak to everyone else and not just listen to me talk. But I want to thank all the panelists for participating over the last 2 days. And I want to thank all the participants for having attended and listened, and encourage all of you to be active members of the Financial Lawyers Conference and participate in our future programs, and think about being panelists yourself. I've been a member of FLC for over 12 years, and I remember at the beginning, everything that I learned was something new because I didn't know anything at the beginning. But still now, even in a program like Nuts and Bolts, which is focused on the real basics, I'm still learning something new, because the great thing about our membership and our programs is we're learning from people who practice in this and have experience. We can all just go and read the bankruptcy code and we can read the case law, but I think that FLC really benefits from the sort of panelists we've had over the last 2 days and on our regular programs by getting insights into their experience and how to apply the law, how to think of creative applications of the law, what works, what didn't work, why and why not, how it might be done differently. And that's an excellent resource for all of us to improve in our practice, to learn more, and to build a collegiality amongst us that will help our clients and ourselves as we try to work through these sort of financial issues for our clients. And it's something that I found extremely valuable. And if you have enjoyed the last 2 days, I would encourage you to think about signing up for our annual seminar, which is going to be at the Lodge at Torrey Pines, March 17, 18, 19 this year. We still have some spots open. It's sort of the high-end version of Nuts and Bolts. Nuts and Bolts is the kind of basics of bankruptcy and financial commercial law. And the seminar is really the high-level stuff. And don't be intimidated if you're new to the practice area. I participated at a seminar when I was a first-year associate, and it was a little bit scary, but I learned so much. It was a great experience. So thank you again for everyone for participating over the last 2 days. I hope you will be active participants in Financial Lawyers Conference now and into the future. And I look forward to everyone talking during our coffee talk. All right, and I'll turn it over to Leslie, who will, I guess, bring us into the proper format for that discussion.
Yes, thank you very much, JP. So at this point, everyone is welcome to unmute themselves as well as turn on their cameras. If anybody would like to go into a breakout room and have a conversation with another person that you wanted to set up, I'd be happy to move you to a breakout room. At this point, you should all be able to unmute yourselves as well as start your own video. So we can't have everybody be shy. Let's go.
Leslie, I think breakout rooms may be a good idea. Do you want to try maybe 3 breakout rooms?
I'd be happy to put people in breakout rooms. Yes, we do it all the time. Let me do that for you right now.
Hi, John. Haven't seen you in a while.
Hello, Seth. How are you?
Good, thanks.
So JP, if I do 3, it's going to be close to 7 people. If I do 4, it goes down a little bit. I think we might be better with, well, actually some people are leaving, so I'll go ahead and do the 3.
Mhm.
All righty. I'm going to go ahead and have you in this breakout room for 15 minutes. You're more than welcome to move to other breakout rooms. People can move themselves, and then we can all rejoin in 15 minutes. I can reshuffle the rooms and we can do it all over again. So enjoy yourselves for 15 minutes. Welcome back, everyone.